A civil trial for organizers behind the 2017 Unite the Right rally in Charlottesville, Virginia, is in its fourth week. 4 years ago, several right-wing groups marched through the streets of Charlottesville, protesting the removal of several Confederate monuments. Many carried tiki torches and violently clashed with counter-protesters. One person was killed and several others were hurt when a driver plowed his car into a crowd of counter-protesters. 10 plaintiffs are suing the organizers. They claim rioters violated their civil rights and caused them physical and emotional injuries during the demonstration. Defendants have argued there was no conspiracy leading up to the rally. They also say they had a First Amendment right to protest. Homeland Security and Justice reporter Nicole Sganga joins me now with more. Nicole, thanks very much for being with us. So the plaintiffs' attorneys have wrapped up their presentation of evidence. How are they attempting to depict an intentional planning of violence by the defendants ahead of that 2017 rally?
Well, Elaine, attorneys for the plaintiffs have really woven together a series of messages, social media posts, even podcasts to make their case for what is being called conspiracy to commit racially motivated violence during that deadly August weekend. And in some of these messages, participants describe the use of flagpoles, shields, even cars as weapons. Rally organizers and known white supremacists Jason Kessler and Richard Spencer, both defendants here, exchange messages about raising an army and the cracking of skulls if it comes to it. And plaintiffs' attorneys have presented evidence showing defendants bragging about violence, including video of Christopher Cantwell, one of the defendants here, a known neo-Nazi podcaster, displaying several guns that he brought with him to the rally. Earlier this week, attorneys even arguing that defendants instructed participants at the rally to mislead law enforcement, with Jason Kessler telling followers in a Facebook message, if police ask how many people you have coming, don't tell them. And Kessler went on to say he believed efforts would be thwarted if law enforcement thought more than 400 people were expected, even though organizers privately touted a number around 800 to 1,000 people. Now, there are 24 defendants here, including some of the country's most notorious white supremacists and leaders of long-established hate groups. But we also shouldn't lose sight of the plaintiffs, 9 current or former Charlottesville residents, including several former University of Virginia students who say they've endured both physical and emotional trauma, injuries as a result of the rally, and of course that torch-lit march you might remember you referenced earlier on UVA's campus the night before.
Well, Nicole, how are some of the defendants using the trial to further spread hateful messages?
Elaine, even though some of the defendants have been kicked off social media platforms like Facebook, some have found a new stage to amplify their racist views, and that is the trial itself. Hundreds of public citizens, journalists, plain old spectators dial in every day. I'm one of them. And, the defendants have been using that as a platform, a small handful, also calling into far-right podcasts, radio, YouTube shows during the trial to give their take and purport their views. Up until a few days ago, defendant Jason Kessler had actually been messaging his followers from the courtroom in real time in a large group chat. During the trial, defendant Christopher Cantwell, who's representing himself, name-checked Hitler, used several racial slurs, and condemned Antifa activists within the first few minutes of his opening argument. And since in several instances, defendants have participated in what's called doxing, publicly uncovering personal information about private citizens as they've cross-examined plaintiffs on the stand. It's something legal experts have called a really dangerous precedent.
Well, does spreading those messages, Nicole, potentially expose them to bigger legal problems?
Yeah, this kind of behavior, Elaine, is really not doing any legal favors for the defendants here, who are, again, accused of conspiracy to commit racially motivated hate. And there are actually more examples of those defendants representing themselves, making legal choices that are hurting them. Richard Spencer and Christopher Cantwell, for instance, both filed motions to dismiss the lawsuit earlier this week against them due to what they called a lack of evidence. And that was shot down by the judge here, Judge Moon, who get this, came out and actually said the plaintiffs had shown proof that they had conspired to commit racially motivated violence at that Charlottesville rally. The judge reminded defendants that the court is required to view all the evidence in a light most favorable to the plaintiffs during this civil trial, and even went on to present a handful of examples of the exchanges by both men exhibiting plans to commit acts of violence. So in short, their motions to dismiss here really backfired.
So Nicole, what is the time frame here? What are we looking at as far as a resolution?
Yeah, well, the plaintiffs here are seeking monetary damages from the organizers, and the goal at the end of all of this is to effectively bankrupt the organizations here, send a message to white supremacists nationwide that this will not stand. In terms of the timeline, tomorrow kicks off closing arguments. The plaintiffs get 2.5 hours to present their final remarks to the jury. The defense gets 3.5 hours. Judge Moon told the court he'd like to see the jury have all of Friday to deliberate, and if all goes according to plan, reach a decision before the weekend. Now, that may or may not happen. Recall that there are 24 defendants here, and the jury has to make a decision on each of them. But the hope is for the jury to be able to return to their families free of their civic duty by Thanksgiving. This all to be wrapped up before then.
Well, how could this verdict implicate former President Trump, Steve Bannon, Rudy Giuliani, and others who've been accused of inspiring violence ahead of the January 6th attack on the U.S. Capitol?
So, Elaine, the civil rights organization Integrity First for America that's backing the 9 plaintiffs here, they're actually using a 150-year-old statute called the Ku Klux Klan Act to try to hold defendants accountable here. And it was enacted back in 1871 and designed to protect African Americans following racial violence and terrorism in the South. But the Reconstruction-era law still has real utility today, and it could implicate former President Trump, his allies Steve Bannon, Rudy Giuliani, and others who have also been accused of inspiring violence, including racially motivated violence ahead of the January 6th attack on the U.S. Capitol. In fact, Capitol Police and lawmakers are actually relying on the very same statute to bring to bear their own civil lawsuits following January 6th. Elaine, I asked the executive director of Integrity First for America, Amy Spitelnik, about this when the trial first kicked off, and she called it sad that the KKK Act is having such a resurgence in the year of 2021. She said it's just one indication that violent extremism and white supremacy is also having a resurgence, but she said, it's a reminder that it's time to take action for the group.
All right, Nicole Sganga, we know you'll continue to watch this for us. Nicole, thank you very much.
Thank you.